Oh boy, alrighty peeps. I have about 10 minutes to fish before I head out to Zero Hedge's studio to moderate a debate between Roger Stone and Papadopoulos and Michael Tracy and Richard Painter. The debate question is whether or not Trump should be the next president. I'm gonna catch a fish before I go there, but give a bit of a highlight. And by the way, before we get into the vlog, I'm looking out for alligators. Don't worry, I'm in a place where big gators don't get in because of gates. So I think I could take a 5-foot alligator, but they don't just jump up on you. You have to see them, they have to be. There's no alligators here, don't worry, I'm watching. The news of the day, we're starting the week with something of a small white pill, a Tic Tac, if you will, that's my joke. The Court of Appeal in New York, I just had a bite on the first cast. The Court of Appeal in New York has granted in part Trump's motion for a stay of New York Nipple Judge Engoron's ridiculous court order pending appeal. We went through the motion for a stay. It alleged irreparable harm if he were required to post the $455 million bond or amount of the award pending appeal, because you can appeal and you need to post the amount of the award. So it would have been $455 million cash sitting in a bank account at the court, or a bond. And the irony or paradox of the bond is that it would have required $1 billion of liquidity in order for a bond company to issue the $450 million bond or the $400 million bond. It was a practical impossibility, as Trump alleged in his pleadings, to be able to secure a bond in order to appeal this ridiculous ruling. And we talked about it last night during the Sunday evening show with Barnes. I put out a vlog about it yesterday. Is Leticia James crazy enough, stupid enough? We know that she's brazen and corrupt enough, but is she stupid enough to actually start seizing properties to the extent that the Court of Appeal did not grant a stay? We reported last week that she had registered the judgment as a lien against 2 Trump properties. I put out a vlog on that. Trump requested a stay of the order and several other aspects of it above and beyond the amount of the bond. And a small white pill, the Tic Tac of the day, the Court of Appeal, or a judge from the New York Court of Appeal, granted Trump's request for a stay in part and modified 5 of the most important elements of New York Nipple Judge's insane ruling. It's very windy, but I hope it's not interfering with the mic. The judge reduced the amount that Trump would be required to post by way of bond to $175 million. From what I understand, Trump had already secured $100 million. He just posted $91 million bond in the E. Jean Carroll ridiculous award and appeal. So the court reduced the amount that would be needed as bond to $175 million, which, although astronomical and ridiculous, will be feasible. They also changed a few of the other conditions. They stayed the part of the order where New York Nipple Judge Engoron precluded Trump et al. From procuring loans from banks in New York. You imagine the judge issues a near $500 million ruling, and as part of that same ruling, prohibits Trump from soliciting loans from banks in New York. What does that do? It makes it impossible to post bond, basically. This is court-orchestrated election interference and basically lawfare compelled bankruptcy. $500 million order. Oh yeah, and you're also not allowed borrowing money in New York. A couple of the other aspects of the order that are stayed pending the appeal, that members of the family can serve as board directors or continue to be functional in the company, that is also stayed. Trump has, I think it's 10 or 20 days, I think it's 10 days, to post the amount of the award in order to proceed with the appeal, which he will undoubtedly be able to do. 2 aspects of the order were not stayed, and that is appointing a monitor and a board, an independent board of compliance, non-issues as far as appealing the decision go. It goes to show you what the Court of Appeal actually thinks of this insane judge who has now defied the orders of the Court of Appeal, who has been overturned by the Court of Appeal multiple times. Remember that Engoron ordered the dissolution of Trump Enterprises within 30 days of the insane award. That was also stayed, from what I recall. So it's a small white pill, a little bit of touch of sanity, and I am thoroughly convinced it has nothing to do with justice. It has nothing to do with ensuring a fair due process. It's business related. In Canada, remember when Herr Trudeau froze people's bank accounts who were involved with orchestrating the most peaceful, beautiful protest ever? When he froze their bank accounts as part of the Emergencies Act invocation, he undid it, not out of a sense of duty, not out of a sense of justice, and sure as heck not because the objectives had been reached. Word on the street, and I have this from a number of sources, is that he was getting calls from the banks who were getting runs on the money, because when you freeze people's bank accounts, it kind of induces panic even in people who are not wrong thinkers. And people were going to the banks, pulling out money because they no longer had faith in the financial institutions. That's what led to Trudeau revoking the invocation. It was causing economic turmoil beyond his wildest nightmares. I have no doubt that that is what is motivating the New York Court of Appeals to reinstill some confidence in New York State for business, because everybody has been talking about packing up your shit and running. Liquidate your assets, sell it, take your money out of New York, take your business out of New York, and the Court of Appeal has undoubtedly been hearing the panic. And so I think that this is clearly simply motivated by trying to reassure people that New York has not gone full commie, even though it has, and it's safe to do business in New York, even though it's not. So that is the good news of the day. And I'm gonna go get ready, get in a suit, put the top down on the car, and drive over to Zero Hedge Studios. But I would really like to just catch a fish on camera. I mean, I did it the last time on the first cast, but it wasn't a monster. Anyhow, if you like my stuff, you know what to do. Like, share, subscribe, hit the notification bell. I'm looking around for alligators, people. Truth is, actually, in this tree behind me are a bunch of iguanas, and big ones. But when I sat down here, I scared them off and they climbed up the tree. So Viva Frei on Rumble, Viva Frei on Twitter, vivabarneslaw.locals.com for the bestest locals community ever. One last cast, and we're gonna see if we can't catch a fish. And we'll enjoy the sounds of birds and nature with beautiful sunrise. Sun, whatever. Oh, I just had a bite. Come on, one fish, just one fish. It's not gonna happen today. Well, as they say, a bad 10 minutes of fishing is still better than a good 10 minutes of work, unless you do both, like me. So that's it, Viva Frei. You know the vlog, people, with the thing. Peace out. Booyah! And just to read the court order for those who might have missed it, it is ordered that the motion is granted to the extent of staying enforcement of those portions of the judgment. 1. Ordering disgorgements to the Attorney General of $464,576,230.62, conditioned on defendants' appellants posting within 10 days of the date of this order an undertaking in the amount of $175 million. 2. Permanently barring defendants Weisselberg and McConney from serving in the financial control function of any New York corporation or similar business entity. 3. Barring defendants Donald J. Trump, Weisselberg, and McConney from serving as an officer or director of any New York corporation for 3 years. 4. Barring defendant Donald J. Trump and the corporate defendants from applying for loans from New York financial institutions for 3 years. And 5. Barring defendants Donald Trump Jr. and Eric Trump from serving as an officer or director of any New York corporation in New York for 2 years. The aforesaid stay is conditioned on defendants' appellants perfecting the appeals for the September 2024 term of this court. The motion is otherwise denied, including to the extent it seeks a stay of enforcement of portions of the judgment. 1. Extending and enhancing the role of the monitor, and 2. Directing the installation of an independent director of compliance. Entered March 25, 2024.